Good afternoon. My name's Ian Levengood and I'm the managing partner with LeavenLaw. What I would like to do today is spend a few minutes talking to you about the TCPA, unlawful debt collection, and how we can unlock hidden revenues in your firm. Today we're going to discuss three relevant statutes. We have the Privacy and Anti-Solicitation Statute under the Telephone Consumer Protection Act, and then we have two debt collection statutes, the Fair Debt Collection Practices Act, better known as the FDCPA, the Florida Consumer Collection Practices Act, known as the FCCPA, and the Bankruptcy Code, which is something that discharges debts and is a federal law as well. Today what we're going to be looking for and discussing is essentially debt collection calls that are placed to your clients after the creditor or debt collector does not have permission to do so any longer. The statutes that prohibit the communication with a consumer known to be represented by an attorney are the FDCPA, specifically the code section is 1692 CA2, the Florida Consumer Collection Practices Act, or the FCCPA, section 559.72 subsection 18, and then of course the Bankruptcy Code, the stay of creditors, and the permanent injunction prohibit debt collection directly from a consumer. All three of these statutes are statutes that we will use in protecting your consumer's rights and trying to find unlawful debt collection lawsuits that mean revenue to your clients and revenue to your firm. Let's start with the TCPA, or the Telephone Consumer Protection Act. Now, the TCPA is a relatively tough statute, but we're going to focus on one particular subsection of the statute that, in our experience, shows violations of debt collection to a represented consumer. We're really looking for four things here. One, was a call placed to your client. Two, was an automatic telephone dialing system used to place that call. Was an artificial or pre-recorded voice used in leaving a voicemail message, and was the call placed to a cellular telephone service. Now those are four things. We're going to reference those four things throughout today's discussion, but those are the components that we're looking for a valid TCPA claim. So again, what are we looking for in evaluating whether or not there is a claim? There are four fundamental things, threshold things, that must be present before you can consider an unlawful debt collection case under the TCPA. First thing is a consumer debt. Second thing, there must be notice of attorney representation regarding that debt. There must be the automatically dialed telephone calls or pre-recorded voicemails that we recently discussed, and these calls must be placed to a cellular telephone service. So let's discuss a consumer debt. A consumer debt, first and foremost, is an obligation that arises from a transaction. Okay, so it can't be from an auto accident or any negligence or intentional tort. That would not qualify as a consumer debt under the statutes. It can't be from a fine or a penalty. So if someone is collecting for a parking ticket, for instance, you wouldn't have a potential claim. A homeowners association due, this is an unsettled area of the law, but we do think the modern trend under Florida law is that a homeowner's assessment due is a consumer debt that arises from a transaction and is a potential debt that could be the predicate obligation used in this case. This debt must be for personal, household, or family use. Okay, the statutes say primarily, so it doesn't need to be exclusively, but the majority of the use and the debt that results from the item or the service bought must be for personal, family, or household use. Initial purchase, or a one-time purchase, is really important here. Analyze it at the time of the purchase. Was it used for personal or household use at that time? For instance, if you buy a home or condominium and you originally live there, but then move out, whether you get married or move away, and you subsequently rent out that property, I think you still have a very strong argument that the purpose of that debt would be for personal, household, or family use because the initial purpose was for your own personal use. To the extent that there's not an initial purpose, but instead a use of a debt over time, for instance, a credit card. There's no scientific way to approach this other than an almost weighing of the overall transactions on the credit card. If a credit card is primarily used for personal use, I think you have a good argument. If, however, the credit card or a credit line that is used was originally taken out for commercial purposes, for a business that you owned, and was used heavily for business or commercial purposes, even if you have an occasional personal use, the argument could be a little more challenging. So focus on the primary use of the debt. Specifically here, we're talking to many mortgage foreclosure attorneys that are representing individuals on mortgage foreclosure lawsuits and the notes that are the basis for those lawsuits. If those homes, if that real estate was purchased for their personal use, that debt will qualify, and we're finding many violations in that fact pattern. Let's talk a little bit about notice of attorney representation. Anytime a creditor or a debt collector receives notice that a consumer is represented by an attorney with regard to that debt, that immediately revokes any consent for the creditor or debt collector to communicate with your client in any fashion whatsoever. It certainly revokes their ability to call them using an automatic telephone dialing system. Now, what are different ways that notices of attorney representation can be given? Oral notice of representation would qualify. For instance, if your client is called by a creditor or debt collector and they answer the call, tell them to advise that creditor or debt collector that they've hired you for representation regarding the debt. Give them your name, contact information, and encourage them to note the time, the place of the call, and the contents of that conversation. Faxes and letters of representation, written letters, will also work. So whether or not that is something that your client writes to the creditor or debt collector and advises them that they've hired you for representation, that would suffice. Also, if your firm is in the practice of sending out letters or perhaps faxes notifying the creditors or debt collectors of the representation, that too would suffice. What is important is the creditor or the debt collector has received that communication and they have sufficient information on how to contact the attorney. In the context of mortgage foreclosure, again, one of the primary purposes of this discussion, if an attorney has filed a notice of appearance in a lawsuit wherein the mortgage service company or the investor is trying to foreclose the property, this notice of appearance given to the creditor's attorney in the scope of that lawsuit will qualify for notice of representation, not only for the lawsuit, but everything that the lawsuit is standing for. One of the things that the creditor must obtain before they can foreclose the property is a judgment on the note. The note is the personal obligation, the note is the debt. If again it was for primarily personal, household, or family use, and the notice of appearance was filed in the lawsuit, that should be very strong argument that notice of attorney representation was given. The other area that we see this come up is in the context of mitigating loss before a foreclosure is filed. If you or your practice involves representing consumers in short sales or trying to negotiate deed in lieu of foreclosure, anytime this practice is engaged in, the lender will almost always require that the consumer gives authority for the law firm to discuss their personal financial affairs, trying to mitigate that loss, trying to negotiate the short sale. This authority to represent, again, given almost always in writing, with proof that it has been served and provided to the creditor, is also going to be a very strong basis and have a strong argument that that creditor had notice of attorney representation regarding that specific debt. Let's now talk about the debt collection calls. Specifically, we're looking for auto-dialed calls that are placed using, and I quote, an automatic telephone dialing system. This is a term of art that is specifically used and defined in the TCPA. So how are ways that you or your client can identify whether or not calls are actually placed using an automatic telephone dialing system? A couple things to look for, or to tell and ask your clients to look for. When they answer a call, is there a pause when the call is first answered? Do they hear several clicks when they first answer? Or is there just an on-hold message asking them to wait for a live person to come on the call? Any evidence of pauses, clicks, or an on-hold message is a telltale sign that an automatic telephone dialing system has been used to call your client. A pre-recorded voice. This is also something that is specifically prescribed by the TCPA. If your clients receive a voicemail and it is clearly a robotic tone or a repetitive tone, this is in all likelihood a pre-recorded voice. If they receive several of them and they listen to each one of them and they are identical, again, telltale sign that they're using a pre-recorded voice. Again, if there's an on-hold message waiting for the live representative, as previously discussed, this would also be the use of a pre-recorded voice while they wait for the live representative to come on. The last thing I will say is, even if they don't see either one of those two bits of information, the holds, the clicks, or the voicemails, the TCPA regulates not only automatic telephone dialing systems, but what we call predictive dialers, systems that have the capability of storing numbers and dialing consumers either at random times or at predictive times. For instance, when they know someone is getting home from work or when someone may be on the weekend. Long story short, if your client is getting a volume of calls from their creditors or debt collectors, specifically a mortgage service company or their bank on their home, the likelihood that a automatic telephone dialing system or a predictive telephone dialing system is being used to call them is extremely high. Capture the information, coach them up on the telltale signs to look for, and then gather the information to call us and discuss whether or not there is a case. So that brings us to, why would we do all this? What is in it for your clients? Well, first and foremost, the TCPA is a strict liability statute. Okay? There is no duty to mitigate, and there is no bona fide error or defense that will excuse liability if all the fundamental tenets, the core tenets, are present. The statute provides for $500 per call. Again, I want to emphasize this is a per telephone call statute. This is different than the FCCPA and the FDCPA, which arguably limits the amount of statutory damages to the entire action. So what that means for your clients is the amount of damages that they may be entitled to could be higher, if not much, much higher on a TCPA case. If we have the ability to convince the judge that these calls were placed in knowing, willful violation of the TCPA, the court has the statutory power to treble the damages. That could mean up to $1,500 per call placed in violation of the TCPA. Again, this is a per call liability. The fact that it can be trebled and that we're talking about technology auto dialing your clients, the intersection of those three facts and circumstances many times can spell large damages for these cases. What's in it for your clients in addition to the monetary damage? Well, first and foremost, the harassment, the continued calls, the stress, the anxiety that goes with that, as well as the potential invasion of privacy, that will stop. Dignity. Many times the clients that we're dealing with, whether or not it's someone in anticipation of a bankruptcy, or if they're facing a foreclosure, facing potentially losing their home, the last thing that they need is a constant, repeated, daily reminder that they're past due. This will assist them in feeling better about themselves and about the outlook going forward. It also provides leverage in the event that your client is looking to keep the home. If loan modification is something that they seek, trying to get a waiver of a deficiency on a grossly underwater piece of residential real estate, a lawsuit that has been built and filed against the mortgage servicer will provide tremendous leverage and value to your client in trying to negotiate that result. Last, and perhaps most importantly, the FCCPA and the FDCPA will provide a basis for your clients to have all of their attorney's fees and their costs that are incurred in filing this lawsuit paid for, not by them, but by the offending creditor, the debt collector, the mortgage servicer, or the bank that is making the alleged unlawful calls in violation of the TCPA, the FDCPA, and the FCCPA will be responsible for attorney's fees and costs. That means that these are essentially contingent representation, and there's no out-of-pocket expenditures for your clients at the outset of the case. What is now in it for you, for your law firm? Well, again, this practice area was essentially born out of a volume of cases, a volume of harassment that we found was being incurred and being... So now that brings us to the next question: what is in it for your law firm? Well, first and foremost, increased revenue. As a small business owner, likely much like the attorneys here at LeavenLaw, increasing your revenue without having to increase your out-of-pocket expenditures is critical. This program and this process allows you to do just that. First and foremost, we pay the maximum referral fee as allowed under the rules that regulate the Florida Bar. So because of the potential large amount of damages involved in a TCPA case, we anticipate, or we hope, that this will be a contingent fee representation case, meaning that 40% of the total benefit that is conferred upon clients will be the compensation that our firm receives. What that means to you is 10% of the overall damages will essentially be your referral fee. We've drafted the consumer engagement letters under which we represent our clients to make sure that the benefit includes any type of debt reduction or loan modification that we have negotiated for the benefit of the consumers. So we will capture and maximize revenue based upon that definition in the consumer engagement letter. In short, what this means, depending upon the volume and the number of clients you have, is thousands, if not potentially tens of thousands of dollars of revenue to a firm that represents consumers, and certainly to a firm that represents consumers in a mortgage foreclosure capacity. This also means greater return on your investment dollar. You've already spent money to acquire clients, whether or not it's through the form of advertising, networking, pay-per-click, or your website. You've incurred that cost to have the clients within your firm. Everything that we're talking about here today allows you to capture a greater return without spending one additional dollar to acquire this client. It's potential revenue that's already sitting in your filing cabinets. It also gives you greater customer service. As consumer lawyers, nothing is more important than your reputation and the happiness of your clients in the communities where you work. By helping to defend and stop harassment, by helping to do so without your client having to come out of pocket a dime to do so, by putting damages, money in their pocket, and by helping to recover their dignity and stop the harassment, these are going to be happy clients, people singing your praises in the community and referring more clients to you. In the end, what we've found is this is what I call an upward spiral of revenue and profitability by looking to the existing clients you have, looking for expertise in ways that you can greater serve them, and finding ways to bring that revenue into both your client's bottom line and your bottom line. So now, why partner with LeavenLaw? It's a great question. Well, we've been doing this a while. The predecessor firm has been here since 1972. And all we've been doing in the Tampa Bay area is serving consumers. We've managed through the years of litigation to receive some accolades from our peers and organizations that review what lawyers do. We also pay the maximum referral fee under the rules that regulate the Florida Bar. You will receive 25% of whatever attorney fee is procured on this case. You can also refer clients to LeavenLaw with confidence. Again, we've been doing this now for many years. We've filed thousands of consumer cases. And so with that comes systems that we've built, tweaked and retweaked over the years. Results, we've done very well for our clients and are respected by our adversaries and other members of the bar. And we've now grown to the point where both from a financial standpoint and an intellectual standpoint, we have a good number of resources available to us to be able to litigate these cases. In the end, these are usually multi-billion-dollar companies we're going against. They have very intelligent, well-resourced lawyers. You need to partner with someone that has the ability to go to battle with them. In the end, it allows you to do what you do best and leave the rest, the consumer litigation, to us. We talked about the maximum referral fee. I do reference it here. It is the Florida Bar Rule 4-1.5 F4D as well as G. And again, I can't reiterate this enough. It is critical to us that you realize if and when you partner with us, we're going to be doing this by the exact rules and the compliance of the rules that regulate the Florida bar. It's also critical that you understand, we know you as a small business owner, your clients are incredibly important to you. When you refer these clients over to us, you're referring them for a very specific purpose, for creditor harassment protection and an unlawful debt collection and or a TCPA case. Many times, it will be impossible for us to represent that client without interacting with them. We want you, other members of the Florida Bar, to be incredibly confident that if and when you do refer a client over to us, should that client ever have questions about other areas of the law outside the scope of what we have specifically been retained to do, that we will always turn that client back to the referral firm to make sure that that's not a practice area that they do or that's not a subject matter that they would like to represent them on. Only if and when that has happened and you have said, no, that is not something that we can help them with, if the client turns back to us, would we consider representing them on that matter. Biting the hand that feeds us is not something that we want to do, and this would not be a profitable endeavor for both you and for our firm unless we were honest in how these clients are treated when they're referred over to our office. We briefly talked about the systems that are in place. LeavenLaw has spent years developing a database of creditor, debt collector, and mortgage servicer contact information, email addresses, websites, fax numbers. We will use this information and intelligence that has been garnered, developed, and tweaked to make sure that we are communicating notices of representation to those creditors if and when your clients have also hired us for representation on these unlawful debt collection matters. The form letters, faxes, and emails that we have developed over time we will also put to use for your client's representation. We've spent a good bit of time developing a consumer education and a creditor harassment protection center that is housed on our website. We will direct the clients, your clients, and clients that are ultimately referred to us to these websites where they can educate themselves on the consumer protection laws, educate themselves on the process on how they can use this information to their advantage and their defense, and give them sample forms, sample letters, sample communications logs that they can use to capture this information and make sure that we're building the strongest and best potential case. Additionally, from the thousands of cases that we have filed, we've faced many motions to dismiss. We've faced many motions for summary judgment, and we are constantly trying to continually improve the quality and the improvement processes that are here at the firm to make sure that the next complaint we file is better than the last complaint we filed. The bank accounts that we've developed and the template systems that we've developed we think are exceptional, and they will allow us to represent these clients, these consumers, in the best possible fashion to get the best possible results. That is also obviously true in our discovery template systems and the way that we gather the information regarding the calls placed to the cellular telephone systems. We've put up on the website here in the PowerPoint presentation a couple cases and some exceptional results we've had. Some of them have been settled and are subject to confidentiality orders. Others are still ongoing in litigation, many of which can be seen, reviewed, and retrieved from PACER to just take a look at some of the work that we've done. As you'll see, there are some popular offenders or alleged offenders on this list, and that's why we're talking to you, mortgage foreclosure defense attorneys, specifically here in this presentation, regarding some of the conduct that we have seen from the likes of an Aquin Loan Servicing, a Nation Star, Wells Fargo. Big players in the mortgage servicing game, for whatever reason, continue to call consumers even after they have notice of representation of counsel, and in all likelihood many times after you have filed a notice of appearance and you've been litigating a case potentially for years. Also, I think it's important to point out here, we're talking about a high volume of potential violations. In a firm like ours, for example, we have between 200 and 300 open mortgage foreclosure defense files. We have found consistently that there is anywhere from 10 to 20% of the cases may have violations waiting just unbeknownst to us. Again, the names that you're seeing, major mortgage servicers are tending to continue to call consumers represented by counsel either because the consumer has told them, our office has told them, or their attorneys have received a notice of representation in the case that is pending and being litigated in the state court. We'll go over a couple processes that we recommend to you for reaching out to your clients to inquire and find out if in fact this type of conduct and these types of violations are occurring right now as we speak with your clients. The next slide here, you'll see a couple examples of some of the documents that we've again built and used in this practice. This is an example of a fax of representation that our office sends to creditors, debt collectors, and mortgage servicers, providing notice of representation of counsel. You'll see that the relevant information needed for the creditor, debt collector, or mortgage servicer to find this consumer in their system is provided. It also provides the information needed so they can find our law office and the attorneys that represent them with regard to the debt. Curiously, I have put not only the facts, but the confirmation that has gone through, because in our experience it is critical to be able to show that not only we've sent it, but that we can prove that this individual creditor, debt collector, or mortgage servicer has in fact received the notice of representation of counsel. On the next slide, you'll see an example of a cease and desist letter. And again, this is another form letter that's available in the Creditor Harassment Protection Center on our website, and a sample letter that we will use for our clients and clients that you refer to us to make sure that we are building the strongest potential case for unlawful debt collection. We will let them know clearly the debt that is being collected, the fact that their cell phone number is listed there, and that any and all communications are to cease is clearly spelled out. The faxes of representation that we've just shown you, as well as a sample of the cease and desist letter, are important for a couple reasons. First and foremost, as we've discussed, we must revoke consent. This can be done in several ways. These are but two examples of a written form of consent revocation. It's also important to realize that during your representation of these consumers, whether or not it's in a mortgage foreclosure defense lawsuit or in preparation and in the time running up to filing a bankruptcy, remarkably, creditors, debt collectors, and mortgage servicers will continue to call consumers even after they've been notified of representation of counsel. We will typically continue to provide notice of representation of counsel to these companies even after our clients have told them. We will do it in written form, we will do it via fax, we will do it via mail and letters. This is a critical component to making sure that not only you have a strong case, but you have a strong argument for the trebling or the tripling of the statutory damages under the TCPA. Make sure you're continuing to tell your clients to answer the phone. Make sure you're continuing to have your clients advise these creditors and debt collectors and mortgage servicers of the notice of representation of counsel, and make sure they continue to take good notes regarding the calls that are being placed. We've now given you an example of the Creditor Harassment Protection Center, a snapshot of the website. We've talked about the document center and the documents that are needed for consumers to send letters to these creditors, debt collectors, and mortgage servicers. Communications logs that they can use to capture information on the calls that are come in. There are all housed on this website. There's also information there that your clients can go to look and learn about how to revoke consent. In the next slide, you'll see an example of the creditor harassment protection notification that we give to our clients. After our office has confirmed representation or provided notice to representation, we will send this personalized email to each client of the firm, your clients as well that are referred over, that would let them know the actions we have taken, the steps that we have taken to provide notice or additional notice of representation to these creditors, debt collectors, and mortgage servicers. In this email, there are links back to the Creditor Harassment Protection Center that will again continue to educate these clients, give them links to the document center, and give them step-by-step instructions on how they can help themselves as well as help the case. Again, this is an organized process, it is a systemic process, and it is intended to continually educate our clients to make the cases as strong as they can possibly be. The next slide gives an example of the creditor and debt collector database that we have developed over the course of the many last years in representing consumers against unlawful debt collectors. Again, it is more just shown as a bit of data and information, part of the intellectual capital that this firm has invested in and spent the last years developing to advantage our clients and the clients that you refer over. The next page shows an example of the communications log that we give to our clients and would give to the clients that are referred over to our office to, again, help individuals capture the necessary information to draft and file a pleading, a pleading that is very factually complete. It has all of the necessary information and elements that we would use to not only prevail on the case, but also to be able to make the allegation and argument that these calls have been placed in knowing and willful violation. This is one of the most critical and important tools that our clients use, and spending the time to make sure that they are educated on not only its importance, but how to properly use it is critical to ultimately having a good case. We also provide, as you will see on this slide, a consumer protection hotline, a dedicated hotline at our firm that any clients, our clients and the clients that you refer over, can give to creditors or debt collectors for purposes of verifying representation. We also provide a dedicated email address just for that purpose. So that's a lot of information. What are the next steps? First and foremost, it's important for you as the attorney and your staff to educate yourself, okay, to understand the basic tenets of the laws we're talking about and what is needed, what is required to try and build a good case. So now when you're back at your office, I would also say you have to question your clients. We've seen success in sending either emails to all of the clients of the firm, asking them if any of these 4 things are present: continued debt collection calls, after notice of representation of counsel, on a consumer debt, and to their cell phone. You can do it by calling and following up with your clients. This is obviously a little bit more time consuming, but can be extremely personal, an extremely well-received call. Helps from a customer service standpoint, and it may give you the ability to ask follow-up questions if in fact it seems that there could be conduct that is violative of one of these debt collection statutes. Anytime your clients call into the office, whether or not it's a follow-up call to check on the status of their case, perhaps you're getting ready to meet with them for mediation or loan modification purposes, make it part of your pattern and practice to always ask your clients if they're getting debt collection calls. Always ask your clients if they're getting sent letters that's requesting and or demanding payment. These will be telltale signs and indicators that there is collection activity afoot. Again, each time you're talking with your client, remind them to use the debt collection communications log to write down information regarding each call and to save any letters that they are sent regarding the debts. After you've done that, gather up a potential list of your clients, and then you can email us. Again, we provided a exclusive email address for any potential referrals or leads here on the slide at consumerleads@leavenlaw.com, and also you can call the exclusive consumer law hotline if you have any questions that you wish to ask of our firm regarding a potential case. At that point, we would discuss and work with you a list of your potential clients and cases to evaluate and determine whether or not we think there is a case there, how strong the case is, and then potentially move forward. All of the cases that we represent consumers on, especially those that are in a referral environment, we use a written engagement letter so the clients are expressly notified of what their rights are and what we're doing for them. And to the extent that it's a referral relationship, you will also be listed on there so the client knows what your involvement is and how we will be compensated. Again, all in strict compliance in accordance with the rules that regulate the Florida Bar. We will continue to work with your clients regarding the calls, continuing to help educate them, continuing to help them gather the facts and circumstances and information needed to filing the complaint. We will then file suit, work towards settlement, and get the damages and the referral fee for you and your client. One of the last pages here just lists the consumer law department here at LeavenLaw. You'll see all of the attorneys, the law clerks, the consumer law case managers and paralegals, as well as the other departments in our firm that touch distressed debt, namely the short sale coordinator, the attorney that primarily works on the foreclosures here at LeavenLaw, as well as the partner in charge of the bankruptcy department. All of these people have helped us to build an incredibly profitable and an incredibly protective consumer protection division here, and these are the resources that would be available to both you and the clients that you refer over. If at any point after going through this, you, your staff, or your clients have any questions, we are here to help all of you. It would be our privilege and our honor to help you to identify these cases, to help file these cases, and to help litigate and settle these cases to the advantage of consumers all across the state of Florida. We will look forward to working with you and your call. Thank you very much.